mind. Lay people make mistakes about the law. I teach constantly. Everybody in this room, or most everybody in this room, I have taught. For the last 15 years, I have taught your staff in your chambers at 651 Pine Street. My understanding as a professional, as a lawyer, is that people do a great job with their job and they still don't know everything, and hence, if they're smart enough, they go for continuing education and they get better at what they do. And so the fact that somebody made a mistake, an earlier presentation, they said that a lot could exist, one lot on either side of a fee strip, they're wrong. And I apologize for that. But the fact that they're wrong shouldn't be used against them. They're lay people. In front of you now is the final word as far as we stand on the law, and I want to make that real clear. So who am I? Nobody to you. I am probably the preeminent, as immodest as it sounds, and unfortunately I'm going to get immodest, I am the preeminent subdivision map act expert in this state. I'm regularly called throughout the state to be an expert witness on all things map act. Just happened to be a niche I fell into. I write a book. Most of the time I send it off to all of the cities and counties in Contra Costa as kind of a thank you, this is my home place. I regularly write articles for the California Land Surveyors, and I am in fact their legal counsel. Any news-breaking map act case that has gone from trial court to the appellate courts, I'm likely to have been the litigation attorney involved with it, including helping the county of Napa just win at the Court of Appeals on a very controversial lot line adjustment case that everybody in the state said I was wrong about. The county believed I was right, and we won at the Court of Appeals. It is now the law. So I only tell you that not to brag, not to sound braggadocious, but to tell you that one of the voices that you're going to hear tonight has talked about this and opined about this and written about this long before Mr. Nunn and I crossed paths. In fact, it was a class last year in Lafayette that I was teaching that Will and others from the planning department were in, where this question came up, and I had no idea who the players were. They simply asked me, when a county comes and condemns a fee strip of land between an existing one-parcel ranch, what are the consequences? And I said, well, it depends upon how they take the land. If they take it as an easement, no consequence. The land stays as one piece. If they take it as a fee, you get 3 pieces. And I'll explain that with my little instructor's board here in a second. Staff then sent me a series of emails. I was asked to be part of conference calls, all gratis, all on me, because I didn't have a client. This is what I do. I have clients, I represent people, but I also give back, teaching classes and helping people out. So I got a slew of emails, Donna Allen, Will Nelson, others, asking me to be a part of this email conversation to further explain my point of view, which I did. Make a long story longer, Mr. Nunn ultimately hired me, and here we are tonight. So the things I tell you tonight are not manufactured to be successful on appeal. These are absolutely the things I have taught for the last 30 years. Long way of saying that very short statement. So what am I saying tonight? I'm telling you that under the Subdivision Map Act, there are 2 distinct ways to create parcels. The old-fashioned way, the way we used to do it from the dawn of time up to the late 1800s, and the modern way. The way we used to do it, and government still gets to do it, is through conveyance. We didn't have maps in the 1800s or the 1700s or the 1600s, but way back when, this big world of ours used to be one lot. We've just been busy ever since. And the way we've been doing it is through conveyances. And the MAP Act recognizes that conveyances are fast, and so they gave the government a break. When the private sector decided that they would like to subdivide land, the MAP Act says you must go through a planning commission, you must go through a city council or board of supervisors, your map must be approved with conditions, and you may only record it when you've satisfied the condition, and upon recordation, those lots shown on the face shall be created. Conveyance is a whole different kettle of fish. Conveyance just says, you and I have one piece of property, I break off a piece, I write it up on a face of the deed, you bring it to the county recorder, we're done. Nobody in government's involved. And the MAP Act gave that slick old way of doing it to the government. And so when I look at this piece of property, again like in the MAP Act class, I ask, how did the government take the stuff that they condemned? And if I may, I'm going to go to my little board and pretend I'm a person. Okay, so what staff has failed.
Yeah, I'm going to suggest you get that mic over there.
Sure.
For recording purposes. Hey, there you go.
On it.
All right.
I need
You
one
weren't in
of
TV,
next.
were you? Were you in TV?
I was, yeah, sure. As far as you know, yes. Okay, so with all due respect to staff, and I like your staff, I think they're remarkable staff, and I appreciate their honesty that this is a difficult question. To me, it's a simple question because I like to keep things in those simple blocks. They tend up to be fairly accurate. What people forget in California is that land is three-dimensional. That's not the case in all states, and each state gets to define what its property rights are. In California, we are three-dimensional. It's why you can buy a condominium 300 feet off the ground and own it, and it never touches ground. And you don't own the interest in the ground, your homeowners association does. It's because property in California is three-dimensional. We're used to dividing it this way, horizontally, looking down on it, seeing pieces. But if you think of it three-dimensionally, by the civil code, it goes as far as man can go and high as the heavens if they are in fact above us. So if you think of property, you actually ought to think of it as a big cake. Let's say we have a 5-layer beautiful chocolate cake, and that's your piece of property, okay? If you took an easement by definition doesn't take all of that property that goes to the bottom and goes to heaven, that three-dimensional thing. An easement by definition only goes across the surface. So if I have that one big piece of cake in front of you and you say, I want an easement, I would say, take your finger, drag it across, taste some frosting, that's what you get. I'd still have one cake, I'd still have one piece. But if you said, no, I want it in fee, then you would take my cake, my three-dimensional cake. This would be the clouds above, subject to navigation easements, because there's a point where planes get to go. So the civil code recognizes it. The middle layer would be the surface that we know, and beneath it would be minerals, oil, gas, that kind of thing, because the property owner has all of that in their bailiwick of property rights. If we take an easement, we just scratch the surface, and we still have one piece of cake. But if we take a fee, we take absolutely everything there is, from as high as property can be legally described to as low as property can legally be described, and we take that out of the middle. If Mr. Nunn had this one cake, and Vasco Rd comes along and is not an easement, but is a fee, it took it from heaven to hell and everything in between. So if I take a piece of cake and I cut out the middle of that cake and I walk away with it, how many pieces do I have? That's how simple it is. You could say, well, I don't want you to have two pieces, and there's policy reasons why I don't want you to have pieces, and other people will get mad if I let you have two pieces, but physically a child in your room would say, you got three pieces, right? And then you do that again. You take that same cake and you cut it the other way. And you don't take an easement, you don't drag your finger across the top and take the icing, you take the whole thing, and you walk away with those pieces. And I say to you, how many pieces do you have? I have two. Really? Who got them? Well, the county got the road and the water district got the pipeline. So you have two pieces. Yes, I do. How many do I have? One. Wait a second. You took two and I saw you take two and you say you have two. How can I physically have one? Any surveyor in the world will tell you property are points and courses that close. The end. Points and courses that close. Of those four pieces on your monitor on that board right now, you have points and courses that close on four separate pieces of property. They are physically distinct. They cannot touch each other from the very, very bottom to the very, very top by law. They are being told that they are one parcel not because physically they are, because policy-wise they're afraid of a domino theory that would happen, because lots of other folks have asked for certificates and been denied. And now to change course will have some precedent and some embarrassment. And with all due respect, you have good staff. We all should be embarrassed when we make a mistake. That's the consequence. And we should all do the right thing, even if that's changing what we used to do. That's what you're supposed to do in government. Not perpetuate something just because we did it wrong and we can't admit that we did. So on the face of this case here, Mr. Nunn and Mr. Tamayo have huge lots. Any one of these are bigger than most of the farmland in Brentwood. You wouldn't know from looking at this slide. There's 357 acres on one, 75 on another, over 100 on a third, and the fourth 45 or greater. Each one of these is fully compliant with the general plan, the Williamson Act contract, all your ag zoning. Every one of these is an active farm production. They simply get to exist. Why? Because you decided to take fee instead of easement. Had you taken easement, we couldn't be here. You would have scraped your finger, taken some icing, but would have one big cake. You took fee. Lots of cities won't take fee. Lots of counties won't take fee for this very problem. We can't tell you what to do. You decided to do it that way. You have to live with the consequences of that action. It's the way it goes. Now, I want to take just a second, if I can, to respond to some of the points raised by staff and correct the record. With all due respect, we haven't said some of the things that we've said, and then I promise I'll be available for questions and then sit down. That's the case. We submitted this afternoon, and I apologize for its late date. We only got the staff report at the end of the day Friday. We had yesterday and today to respond to the staff report and get a writing back to you. So I apologize for its late arrival. I'm simply going to mimic in very short form the things we said in that letter. So the staff organized the staff report by taking my November 11th memo and responding to it. What staff says at the back of their staff report is they got a second memo from me July 10th. 2 weeks before tonight's hearing. They chose not to respond to that. They didn't give us the staff report on the 10th when they said it was done. They waited till Friday evening, a little bit of gamesmanship, used to it. But we're prepared tonight. We're ready to answer all of the issues they've raised. The first thing staff quibbles with us is over the factual condemnations. It doesn't make a difference. It doesn't make a difference if it was 1976, 1978, 1994, 1996, 1997, or 2008. We all agree, staff and ourselves, that there are two pieces of property owned by separate governmental agencies, one Vasco Rd owned by you, the county, the other the pipeline parcel owned by Contra Costa Water District. Where we don't agree, we do agree that the four parcels in question are physically separated and cannot ever touch each other, ever. We agree that all four go to as high as property can go to heaven and as low as property can go to hell and can never physically touch each other. Where we disagree is how many therefore we have, 4 or 1. So the first comment they make is about the facts. We don't care about the facts. The bottom line is the law will be the same whether it was a 1978 condemnation or a 2008 condemnation. Secondly, we do not say that the Contra Costa Water District or anybody else is subject to the mapping requirements of the MAP Act. That would be the antithesis of what I have said throughout this presentation, my letter, my book, and everything. We are saying that these were created by conveyance. The simple act of doing a deed that was ordered by a court that says you're losing your land and you're giving it to the government, that's done through conveyance, not mapping. They spend a lot of time in the staff report talking about MAP Act Section 6626, which is the section that says even though you have 5 or more lots you're creating, you can do it with a parcel map, which is generally used for 4 or fewer lots. We're not talking about maps. We're not asking you to recognize a map. There's no map in the equation. This is a straw man set up so it can be knocked down. It has nothing to do with arguments we're making. But it does make for good theater in the staff report. What we're trying to say that is if the condemnation was legal, so must be the consequence. If the condemnation created a parcel that you recognize 2 parcels given to the government, then the consequence has to be that you recognize what you left behind. If I can legally cut you in 2 and take half of you, I can't argue, well, my God, what are you doing with that illegal half right there? You created me. You cut me in half. You're the one who took the legal action of making the conveyance and the condemnation. You can't say that which you left behind is now illegal and you won't recognize it. And the fourth point is that there is no such thing, with all due respect, as sovereign immunity as it's been explained to you. Please. First off, if you're a city or a county in California, you're the most powerful local agencies in California. You have all power to do what's right for your community, except where you bump into statute. Article 11, Section 7 of the California Constitution says cities and counties, or cities and counties, like San Francisco, may regulate for the health, safety, and general welfare of their community, provided they do not do so in conflict with statute. You are the most powerful, and you cannot bump against statute. You can't say, you know, this general plan law is really getting in our way, so we don't really feel like providing housing. You can't do that. You've been told tonight in a staff report that you can. I'm sorry, that's wrong. Water districts have remarkably limited power. Where you are what's called a reserve power agency and you have all the power inherently to do what's right for your community unless the statute says slow down, districts are the opposite. They have no power unless expressly given it to them. And they were not expressly given the concept of ignoring the MAP Act when it suits their fancy. There is no problem with the water district functioning as it needs to function and recognizing the existence of these 4 lots created as a consequence of making Los Vaqueros work. That's the way it goes. And lastly, staff argues And again, I like staff, and so I say these charged words, but I don't mean it to be attacks on them personally. They're good people. But when I see legal arguments that are really stitched together, you know, a wing and a thigh, and you're trying to tell me that's a big piece of chicken, it really bothers me. There is no such thing as the case law that they give you as being appropriate for MAP Act consideration. There is a concept that if you've ever done condemnations, that when Vasco Rd went through and it separated the farmland, if the farmer was able to show that there was a unity of purpose, a unity of use, a unity of title, he or she may have been able to say, you owe me more than Vasco Rd, you owe me for the farm you upset by your condemnation. And the factors are access, the ability of farm equipment to go back and forth. They may be legally separated lots or not. It doesn't matter. The concept is, have you taken more than the actual land you've taken? And if you have to pay more than the actual take, that's known as severance. All of the cases they gave you, some of them are one, some of them are an easement, like our cake that never created. Some of them are already existing lots. But for condemnation law, we call it larger parcel. We call it one uniform operation, a unity of use. It has nothing to do with MAP Act and recognizing lots. It has to do with enterprises. So, last case, and I will sit down, in Los Angeles, an office building goes up, and the Planning Commission changes the zoning in downtown Los Angeles, and they tell you you have to have increased parking. So the business owners, not wanting to be a non-conforming use, they go look around and they buy a parking garage. So now, within 750 feet, as required by their zoning, they own on one lot an office building, and 750 feet away, within the zoning regulations, they own a separate lot with a private parking garage. LA comes along and condemns the private parking garage because they need more parking in Westwood. This is back in the early 60s. They argue, wait a second, you just took my parking garage. You don't just owe me for that. You've now made non-usable, non-conforming my office building. And the California Supreme Court said, for the purposes of severance damages, they shall be considered one parcel. Are they one parcel? Of course they're not one parcel, because the MAP Act recognizes them at two. But a separate body of law that tells you how much we have to pay you said, for the purposes of our condemnation law, they're a larger parcel. So when you see case law that talks about access and contiguity of use, that has nothing to do with the MAP Act. That has everything to do with severance damages. I'm not sure who came up with those arguments. With all due respect, they simply do not fly and will not fly when presented to a court. So I've taken too much time. I appreciate your attention. I'm happy to answer questions. Ours is a simple truth. These condemnations created before. We didn't ask you to create them. You decided to do so. You have to live with the consequences. One last thing, and I apologize. Today we found out that 2 well permits were issued for Parcel A, and we have those designated on your monitor. It's the very large parcel, the one that says 357 acres. Through the Subdivision MAP Act, the issuance of permits themselves are certificates of compliance. And so this unfortunately happens with cities and counties a lot. I represent cities and counties a lot where this happens. When a department that you have issues a permit for a subpart of a lot, you have just recognized that subpart to be a legal lot. So we have a new claim that we've put in that letter, which is just the well permits themselves have sanctified 2 lots on Parcel A. Thank you very much. I appreciate it.
Thank you for your presentation. You know, I might have one question for you that when you were giving your illustration from heaven to hell, it seems as though up in Yellow County and some other counties that have problems with developers buying property and putting together, that they're in the middle of that, and someone says, wait a minute, I have a gold claim underneath your dirt. It's not your property. You can't build there. Are you referencing that now to your same theory, that because I have a claim to a gold mine or gold underneath that property, I own the property because I have that gold claim?
That's a great question. No, I'm not saying that. I'm saying land is three-dimensional. Right. So I'm the owner of all things. And I want to sell to you. I'm looking to get out of the area, but I just so happen to be an oil person or a gas person or an aggregate miner. And I say to you, Chair Terrell, where are you going to put your home? I've got building plans and I'm going to go right here. If I were to trench over here and I'd shield it and you wouldn't see it, would you mind I'll let you pay less for the property. I'd like to put a gas well in, and I'd like to reserve the mineral rights to myself. I'll have an access point over here. I'll take the gas, and I'll let you pay half of what you were going to otherwise pay because I'm going to make a profit off the gas, and you're going to own the land. And you could say yeah or no. If you said yes, then that piece of property, which is three-dimensional, would have pulled out of it the dimension known as mineral rights or timber rights or water rights. And so property being three-dimensional and having different assets that are known as property can actually have those assets divided. It's not a division of land. It is said to be a common division that applies to all the land, therefore not being subject to the MAP Act. So if instead I'm Kaiser and I put in a medical office building and I own the campus and I want to get out of medical office building ownership because it's expensive, and you're a doctor's group and you'd like to buy it, I have to three-dimensionally map that to sever that part of the property and let you own it, and I'll own the dirt underneath. That's how homeowners associations map condominium projects. We actually map the land to be held by the homeowners association, and we map the air to be owned by the people who will own the units. Instead of mapping this way that you're used to seeing, we map this way. So I did the Hollywood and Highlands project, if you're ever in Hollywood. And the Kodak Theater is owned by one group of investors, and the Academy Theater is owned by another group of investors, and the parking garage is owned by the property management company. We did mapping this way and every way because property is three-dimensional.
Okay, and then the next question I had was in reference to the wells that you found on the large piece of, oops, my thing went off on me, on this large piece of property. Now, you're saying there's two wells there, two water wells, or gas wells. I don't know if
water wells.
Water wells.
Yes, sir.
How does that, having those wells, make a claim to the property?
That's a great question. I can't tell you the legislative wisdom or lack thereof for sections in the MAP Act. I can only tell you that they exist. So the MAP Act has a section that says certificates of compliance, you'll do them pursuant to me, and that's 66499.35. And it lists the different things that are equivalent to certificates of compliance. And it says a permit for development issued pursuant to .34. So you look at .35 and you go back a section, and .34 says any permit issued for any kind of improvement or the improvement going in for which no permit is required shall be permitted development for the purposes of .35. And what you realize, to the chagrin of cities and counties, that when you give a permit that recognizes a subpart of what you later try to claim as a legal parcel, that permit said this subpart exists. And if you look at the face of the well permits, and I'll make sure Maureen gets them for the record, they list two separate APNs. On their face, they list subparts of what we call Parcel A. And in doing so, to the chagrin perhaps of the county, they have recognized what the MAP Act says is a de facto certificate of compliance.
Thank you very much. Any questions for the speaker? Mr. Clark?
So are you saying that People v. Thompson was a severance case and not a case deciding whether or not there were two parcels?
That's exactly correct, sir. In fact, I can tell you the facts of Thompson if you're interested.
I'm sorry?
I can tell you the facts of Thompson if you're interested.
I am.
Thompson was a case, if I remember my cases right, that were three parcels. It was never clear if they were actually one because in severance parlance, we don't talk about legality of parcel. We're looking for an interdependence between uses. In Thompson, there were three separated uses. A marsh slough on the seaward side of Highway 101, a basically fallow, non-usable piece on the leeward side, and adjacent to it, a farmed piece. The question was, when Highway 1 first went in the 20s, was there severance? They only took Highway 101 as an easement. So we didn't have any of the things that we're talking about today. They didn't have a creation, and Mr. Thompson didn't make a claim that he had his lots created. What he was trying to argue is that 50 years later, when they put up a guardrail on the leeward side of 101, he was prevented from going across the highway to his beach. So we have this beautiful beach. We have this on the seaward side that he owns. We have Highway 101 that was unguardrailed, and it was only an easement, and then we had his slough and his farm. And he could go back and forth all of the time. He then argued when the state came back and decided to redo 101 and make it wider, like Contra Costa Water District redid Vasco Road to do the reservoir, that the redoing of 101 and moving it and making it bigger and putting up guardrails now had severed his land. In order for him to win, he had to show, even though physically separated, that there was a unity of use, that he had used to have access across them, and therefore they owed him more than the physical take, but the property they had severed from his interdependence. And that's how severance works. And the court found them to be a larger parcel and awarded him severance damages. That means he got more money than the take itself. That's what a severance damage case is looking at. Not physicality, like the MAP Act looks at, but whether your enterprise is such that when I condemn portion of it, I domino into other things that I should likewise have to compensate you for.
So after People v. Thompson, does Mr. Thompson own 2 parcels or 1?
It doesn't matter because People v. Thompson doesn't answer that question. He owns a, quote, capital L, capital P, larger parcel known to be interdependent so that anything done to one part where he has blocked access should be compensated. How many parcels he has is irrelevant. What is relevant is his enterprise and the interference to his enterprise that the condemnation creates. It is a damages question, not a legality of parcel question. That never came up in that case, nor any of the other ones. And the one that does tell you all the things I'm telling you is a California Supreme Court case that they do not cite to.
And did you cite it in your letter?
I did indeed.
Which case was that?
It's the Los Angeles versus Wolf, the 2 I just gave you, the parking structure and the office building.
Is that the only authority you have for that, or is there an
do
attorney
you need
general?
more authority for me telling you that something is nonsense? I am telling you that the cases they give you are nonsense. I can give you a parade of cases that say they're
back
nonsense.
up. That's not what I'm asking.
Okay.
So they have offered to us cases that they claim are authority for their point of view.
Correct.
Do you have cases or Attorney General's opinion, Wolf, for example, the one you just mentioned? Do you have others where it says that what you're proposing?
Let me correct what I've said. I offered you Wolf to show you the ridiculousness of their argument. Wolf also is not a MAP Act case. I could argue to you something about mail, and you say, I'm not talking about Postal Service, I'm talking about one of the sexes, and I'd go, oh, sorry, my bad. That's how remarkably distinct these 2 bodies of law are. They have argued to you condemnation severance that has no relationship to the Subdivision MAP Act at all. Do I have cases that support my concept? Absolutely. Where are they? In the November 11th memo I sent to you, in the July 10th memo I sent to you, and in the letter today. It is full of Attorney General opinions that tell you that not only is the parcel created, but that the parcels around are created. Staff cites to one of those Attorney General opinions in its staff report and talks to a 2003 Attorney General opinion. In that 2003 Attorney General opinion, the Attorney General said the lots are created and the remnant lots would then have to comply with the MAP Act. And my response is, okay, they recognize the lots were created, that's all we're asking you to do, and compliance with the Subdivision MAP Act is a certificate of compliance. That is how you sanctify an already created lot. That's what point 35 and point 34 say. There are situations when a lot was created illegally by conveyance, or by a city by conveyance, where no map is required. So we're not going to use the mapping sections of the Subdivision Map Act. We're going to use the compliance section, which is point 35 and point 34. So the Attorney General said the lot was created, now bring it into compliance, and we're asking to bring it into compliance through the vehicle known by the MAP Act as certificates of compliance. So yes, I've given you case law, I've given you Attorney General opinions, and most importantly, because they're the first one listed in a case, I've given you statute. Statute's number 1, cases number 2, Attorney General's number 3, and the statute is remarkably clear.
that satisfy you, Mr. Clark? Well, I mean, any more questions?
No, I have no more questions.
Okay. Commissioner Steele?
Okay, I have a couple of things, just so I understand the discussion about the highway separating the property with an easement.
Sure.
And I do have a background in architecture, so I'm understanding what we're doing, but just so I can get the sense of where you're going with it. The easement still allowed the property to go underneath the pavement portion, which was the easement.
I'm sorry?
The pavement for the roadway, which was an easement.
For which case are we talking
The
about?
case that you were talking about in Southern
Thompson?
California that had the property that was on the beach.
Right.
That was an easement, correct?
Correct. Yeah, 101 at that time was an easement.
Okay, so that meant that his property was bounded and just the roadway went across his property. His property was still underneath it. His mineral rights were still there. His water rights
Absolutely.
were still there.
Absolutely.
It wasn't divided. So if you were to
The
look...
roadway didn't divide it, and the case doesn't deal with what did divide it, if anything, and nothing did divide it.
Right.
Nothing did divide it.
In the record, it still has meets and bounds that creates one solid parcel that just happens to
I
have an
don't know
easement
if it
over
was a
it.
book map reference that Mr. Thompson had or meets and bounds. A book map reference could be, from the early teens, and you'd still have a book map reference. Meets and bounds is a unique thing. I don't know that Mr. Thompson had meets and bounds.
Okay. Well, I'm looking at the pieces of property that are sitting here, and from the discussion that you've had earlier, and I believe that, in listening to Will, I believe this is correct, that the Vasco Road parcel and the Water District parcel have their own separate parcels. They are that.
Yeah, they are not easements. They are fee. So if we had an easement, we would have no claim to you. When you take a fee, you take all rights that can be held, subject to a reservation, as Chair Terrell and I spoke to. There was no reservation here. You took everything. So you took everything that can be real property, you took. If you had only taken easement like Highway 101, even though that case has nothing to do with the MAP Act, there wouldn't have been a lot creation from that case. There is never lot creation by easement. And the Attorney General and myself have regularly said that. Why? Because an easement's not a cleaver. It's just something that lays on top of something. But a cleaver is fee. And when you cleave, you create.
Well, and that's where I'm heading with the items that have parcel numbers to it. My experience is I can go to the book and the page number there and find the parcel and then go find the information on, if I'm the surveyor walking the property, exactly what bounds that property.
Right, through a modeling.
And from what you're talking about here, that boundary is the cookie cutter that goes straight up and down in the dirt, up in the air. We then move into Vasco Road that has its own defined area again, and then parcel D, parcel C, and parcel B, each one of them independently referenced, each one of them independently with survey information about it that I could find if I was going to be developing that, which to me ends up defining that we have 4 separate parcels, basically surveyed and cookie cuttered, completely different from the easement argument.
I agree with you completely.
Okay, I'm just trying to get that all in my head.
Yes, I agree with you completely, and I think you've captured it. That's the difference. That when we gave the part we gave, we ended up with 2 new deed descriptions, just as you said. We ended up with the surveyor's description of the conveyance deed that the court orders to make happen, and you end up with the results of that, which is, in that situation, probably a meets and bounds description. Both for condemnations like this, Mr. Thompson had probably a book map because we didn't have a fee conveyance. Had we had a fee conveyance, he probably would have had meets and bounds, as you suspected, because that's how we then adapt out of book map reference into on the ground.
Right. Okay. I got it. Thank you.
Thank you.
Any other questions of the speaker?
I have a question.
Mr. Clark?
I'm looking back over the material you've submitted, and to me there's 3 questions. The first is, does the conveyance to a government agency of a strip of land that physically divides an existing parcel into 2 or more parcels constitute a division, which I'm told is defined by the Subdivision Map Act as a parcel? And then the second question is, if so, does the Map Act require a map And the third question is, in particular, in this case, 4 parcels, can they be sold, leased, and financed? Now, the second and third question, I understand and I accept your reasoning on, but I don't see the authority to answer the first question of whether a conveyance to a government agency of a strip of land that physically divides an existing parcel into 2 or more parcels constitute a division. And I would like to see that authority.
It is in Map Act section, Government Code section 66428A2. I believe that section is also referenced by staff.
Okay.
66428A2. A1 is railroads, A2 is government.
Well,
what it stands for, if I may, what it stands for is what I said at the beginning. So the MAP Act uses a word that uses a word that uses a word. It's like the word, I know, Commissioner Clark, you're very familiar with CEQA. So I know that you know that the word project means project, except when it means project, or, in the alternative, a project. We have a bad way of using the same word to have multiple meanings. When the MAP Act says in 66428A2 that the government conveyances to or from a governmental agency, whether they be fee, license, easement, whatever, are not a division, they mean you don't have to map it. That's what they mean. You don't have to map it. You're never going to have to map.
Now, I understand the map argument. I don't think you have to have a parcel map or a vesting tentative map or anything like that. But I happen to have 66428A2 in front of me, and I don't see anything that says that a conveyance to or from a government agency creates 2 parcels.
But let's walk through it. Because if I always tell people, love, devotion, and surrender. Are you willing to surrender? Because if you're not, we'll just argue. But if you're willing to surrender, then you can take the facts and answer your own question, right? You know that you have 2 new parcels, right? The 2 new parcels that you have are held by Contra Costa County, Vasco Rd, and Contra Costa Water District, the pipeline. You know from your staff report that those 2 lots were created by a conveyance through the face of a deed, because they told you so, and it's on your map, and if you ran title, you'd see that there were owners, right? So, since matter cannot be created, only transformed, if we took what used to be 1 and created 2 more, we at least have to have 3, right? The one you own, the one the district owns, and the one they say we own. So through a conveyance, we just created, didn't we?
You know, Mike, I understand what you're saying, but it's not answering my question.
Maybe the question isn't answerable because...
Well, the question is right out of Sandy Skagg's memo on this. And the question is whether or not there is an authority that says a transfer of a strip of land creates more than 1 parcel for the owner of the parcel that was split.
Okay.
And you cited
Attorney General opinions.
66428A2, and it's not there.
Then you and I would respectfully disagree with each other. I absolutely think it's there. I absolutely think it's reflected in 3 separate Attorney General opinions that I provide, and they provide you the rationale.
I've read those Attorney General provisions.
I can give you an argument. I can't change your will or your mind. I can only give you an argument. But asking me to convince you is something I don't control.
That's very slick. What I'm saying is the question is, does a conveyance to a governmental agency of a strip of land that physically divides an existing parcel into 2 or more parcels constitute a division? And
it creates a creation. It constitutes
and
a creation.
all I'm asking for is an authority for that. I want to find...
Do you want me to pull the memo out and give you the 3 Attorney General opinions?
Well, when we have a break, maybe you could do that for me, because the authorities you're mentioning in your memos deal with other issues like mapping and whether there has to be a map. And
they were not mapped cases. Not a single one of those Attorney Generals deal with a map, with all due respect. They do not. They deal with conveyances through condemnations that created parcels. And that's what they say. Whether you choose to buy that argument, whether you're convinced by that argument, I leave you to you. But those, from my perspective, absolutely conclusively. And the facts are clear. You took your half, and you're trying to tell me my half doesn't exist. You created my half, but won't recognize that the consequence of your action is that recognition.
Yeah,
and then
it's
you ask
ironic
me
that you say
to
that,
justify
Mike,
that.
because I'm not saying that. I'm trying to find for you. I'm trying to find for your client. I've been through this meticulously for hours and hours and hours. I've read attorney general opinions. I've read some of the cases that were cited. I've read the summaries of the cases.
That's right, but those cases have
Excuse
nothing
me
to
for
do.
talking while you're interrupting. You cited a statute, and I looked at it, and it doesn't answer that first question. It deals with a similar but different subject. And then to come back at me and say, well, I can't convince you, you know.
Really?
I mean, I went to law school too, Mike, all
Well,
right?
I appreciate that. You tell me when it's okay to answer you, because I don't want to be accused of interrupting you. I thought we were having a free-flowing back and forth, but I don't want it. You're in charge, I'm not. So you tell me when it's okay to respond.
Well, I'll read to you what the citation is that you gave to us that said, essentially answered that first question, because I'm on board for questions 2 and 3. I'm just looking for an authority that says a conveyance to a government agency of a strip of land that physically divides an existing parcel into 2 or more parcels constitutes a division as defined in the Subdivision Map Act. That's the question.
But factually, you've answered it. Factually, you've answered it. Isn't some things, I mean, you're a lawyer. You remember the first case?
I'm not a lawyer, but go ahead.
Okay, well,
I have a law
you
degree.
can read, you have a law degree, and you can read cases. And before Marbury versus Madison, we didn't know what executive privilege was. And 30 years after the Constitution is signed, some guy, John Marshall, sticks out his neck and tells us what it is, and from then on we know what it is. So yeah, there is sometimes a position people take in the law that hasn't yet been embraced by a court, like we did 2 months ago for Napa on lot line adjustments. Since 1976, there's been lot line adjustments. Hasn't been a published case until 2 months ago. So if you had asked me 2 years ago, where's that published case, I'd say it's just an opinion, and here's the A equals B equals C, A absolutely has to equal C rationale, but I don't have a case to give you. So will there be a case on this? Who knows? Maybe this one. But here's the deduct. The deduct of the A equals B, B equals C, therefore A has to equal C, is that you've recognized somebody got some of our land. Somebody got some of our land, and they recognize it as a new parcel, theirs. And by deduct, if you take something from a whole, you must have more than you started from. By deduct, if that line goes all the way through and physically separates it, their actual indicia of ownership is that they go to the bottom and they go to the top, and their courses have points that close. If you ask them to ask them why their lot is legal, they'd tell you that's why. Ours do the same thing. But you want to tell me there's not a case that says that. And so even though I'll recognize mine that I took, I won't recognize you, which is the consequence, because you don't have a case to tell me. So I have the statute, and I have attorney general opinions, which are no more than persuasive authority. They're just lawyers too, but they tend to do a fairly scholarly job, and most of us use them until we disagree with them, and a case may agree or disagree with them. That's all I got. If you need more, I don't have it. I just have reasonable thinking in the things I've given you, but I don't have a case. So you have to be that legal mind that can make the analytical jump or not. I can, because it makes absolute sense to me. But I'm not you, and I don't mean to be offensive to you. I'm just saying I can't be asked to task into convincing you. I can just give you my argument.
Okay, Commissioner Steele?
Just so that I'm clear, because I'm trying to actually reference what you have in front of you in the video. Federal or state on that map act? That's a federal?
State.
It's a state act.
Yeah. The California Government Code, section 66410, then we throw in Latin just because it's confusing. Et sequium, which means and those sections that follow. It goes all the way up to 99.39, I believe.
All right. Do we have any other questions of the speaker? Thank you very much. If you need to rebuttal, you'll have
I
an
won't be
opportunity to
far.
rebut.
Thank you.
Next speaker, Mr. Nunn, did you want to speak?
Yes, I'm just here to discuss the practical side of this, not the legal side of this. We've been farming in Brentwood since 1885. We were farming other places in California before that. We bought this property with Jeff Tamayo, and we annexed it to the East Contra Costa Irrigation District. That's the two main water suppliers out there of ag water are Byron, Bethany, and East Contra Costa. To do that, we went through LAFCO, and it bordered the irrigation district or the irrigation districts on three sides. So it's the first annexation for farm purposes that I know of out there in about the last 40 years. There's been a number of de-annexations and a couple of annexations for golf course purposes, but there hasn't been any for ag. This is an ag property. It's in Williamson. Okay. And it is larger by a factor of 3 or more than any other farm in Brentwood. The largest farm that I know of is 200 acres in Brentwood. The largest farm that I own in Brentwood is 157 acres. Okay. Brentwood, by its geography, by its cropping cycles and what have you, doesn't lend itself to farming sections of ground like you might do in Westlands or some of the places down on the west side of I-5. It lends itself to smaller parcel size. And so I bought this together with Jeff Tamayo, and Mr. Tamayo is very knowledgeable about wine and vineyards and has some vineyards of his own. He wants to enter a vineyard contract with a very, very good winery from Sonoma that only takes kind of upper quality grapes if you can figure out the difference in quality when they're basically grown in the same place. But anyway, they don't want to be associated with the kind of blue collar or valley winery that I'm going to use on the larger piece of the property. They want it separate property. I also want this division so that I can arrange so that I have parcels that I own and Mr. Tamayo has parcels that he owns. We would like to be able to do that. My further need for these certifications is I'm doing some estate planning. I'm at that stage in my life where it seems prudent to do it. And there's also some existing tax laws that are only available through 2012 that we think are not going to be available in 2013, so it's prudent to get these things done. If you're going to describe these parcels, I think you have to describe them each independently of the other because somebody else owns the land in between them. And I think in any basic rationale, there are 4 separate and distinct parcels. There's no non-agricultural development plans there, and there's none forthcoming. There is it all complies with Williamson in terms of acreage. The minimum acreage is 40 on Williamson in that area, and the smallest of these is larger than 40. And so that's the purpose of just recognizing reality. Now, the county doesn't seem to want to recognize reality. They seem to be fearful that I might be a developer that wants to build 4 houses because there would be 4 parcels. Well, you know, I don't want to build 4 houses. If I did, I didn't think of 4 houses on 600 acres as a big deal. But anyway, that's not the intent. What the intent is to get the majority of that planted in the vineyard. What the intent is to have a winery there on that intersection that you see where Vasco Rd and the pipeline come together, because that is my only legal access between two of the parcels and the other two of the parcels. I'm severed by Vasco Road, and I do not have the right to access across Vasco Road except in that one intersection. And so I'm hoping to put a winery there, and that will be attractive, and it will be a real bonus. The whole development will be a real plus for the city of Brentwood as you drive in on Vasco Road. Any questions?
Do we have any questions of the speaker? I have a question.
Yeah.
And, you know, we started out with staff saying either 2 or 1. Now you're saying 4. I've been looking at the map. I've seen the division of Vasco Road. I've seen the division of the Contra pipeline. So are you saying that there are 4 pieces of property here now? Because in the beginning, all I heard was 2 and 1 or 1 or 2. Now I'm coming to 4. I can easily see 4, but I've been trying to figure out how to get the 2 and the 1 in there. So what you're now saying is that there's 4 pieces of property?
Mr. Tamayo and I own almost 600 acres there, okay? And other people own strips that go through it and create our ownership, break our ownership into 4 parcels.
Okay, so we have a partial that's 357, one partial 74, one almost 46, and another one 108. Does that sound about right?
That sounds about right.
Okay. Okay. You know, you've helped me a lot. You know, the legal things here, I'm just a construction person. I build the houses on top of the land, and I don't know what's underneath or how far it goes. So you've helped me understand a lot just with what you're saying. Thank you for that. Do you have any other questions of the speaker? Thank you very much. Next speaker, Seth Adams.
Chairman Terrell, members of the commission, I'd like to add a couple of other things to the discussion so far, including a little bit of location. It was mentioned that the map had been turned so that north was to the left. To the south.
Okay, Seth, excuse me for a second. I don't know if you gave your address for the record. I apologize.
Dave Mount Diablo's address is 1901 Olympic Boulevard, Suite 320, Walnut Creek, 94596.
Thank you.
To the west or below the map is the new 4,000-acre Marsh Creek State Park. The property is also downstream from Los Vaqueros Reservoir, and it's crossed by Kellogg Creek. And the several parcels include wildlife corridor connections that were created underneath the bypass when that was put through in order to continue to allow wildlife there. I have a letter here, which I'm going to give to staff, which essentially says that we agree with their position.
Excuse me. Mr. Chairman, can you ask him to speak into the microphone for recording purposes?
Yeah.
I have a letter that I gave to staff, which essentially says that we agree with staff's position that certificates of compliance aren't warranted in this case, and that there's one legal parcel, not 4. But of course, that's our opinion, and you have staff's as well. We've been following this application, which is still open, not the one that you're considering now of compliance, but the proposed subdivision into 4 lots since 2008, and it would be a lot simpler if this were the case. We don't believe it is. But our take on this situation is you've got an opinion from your staff, you've got an opinion from the counsel of the applicant, and it essentially comes down to an argument between the different experts and which ones you believe. Our lawyers are obviously skilled at arguing both sides of an argument. I'm curious to see how county counsel would weigh into this. If in fact the nuns do deserve certificates of compliance here, then that would be useful to know. Otherwise, what we've got here is an attempt to get around the Subdivision Map Act, which requires various kinds of mitigations in exchange for the new entitlements that would be given to the landowner. So we would like to see what County Council's opinion on this is, and would appreciate additional information. Thank you.
Do we have any questions of the speaker?
Yeah, can I make a comment?
Yes, Commissioner Clark.
As I'm sure you know, county council's opinions, and I understood that there was one in this case, are confidential to the director of the department, and we have not seen them. So we're relying on the staff report and the public's input.
No, actually, I didn't know that. I've heard county council give opinion on occasion to the Board of Supervisors or at other hearings. If they might have a white paper or something about that, maybe that's held to a different standard. But I've heard.
I'm sure both the director and, not both the director, that the director and the board can waive that privilege if they want. But it exists.
Good to know.
Okay, any other questions of the speaker? Thank you very much. Do we have any other speakers? Yes.
I'll hand this over when I'm
Yes,
done. I'll be very brief. Bob Nunn, and this is probably
We'll need your address,
Sure.
Mr. Nunn.
Bob Nunn, 10500 Brentwood Boulevard, Brentwood, California. And you've probably all grasped what I'm about to say, but this is purely from a layman's perspective and no legalese, no courses in law taken by the speaker. But I am in the oil and gas business, so I do deal with easements quite often. And the simplistic view I have on this is, number one, we didn't ask for the takes to take place. But had they taken an easement, you would find the description of this property being the one 585-acre parcel with an easement. Now you have takes that are specific parcels owned by specific entities, owned in fee. And if you look at the description of that parcel, whether you think that's one or four parcels, it will describe 4 individual pieces of land. If it was an easement, it would describe one with an easement. It describes 4 individual pieces of land created by the take. How can that be one parcel?
Do we have any questions of the speaker? Thank you very much for your comments. Do you have anything else to present to us? Any other items to present to us for consideration?
No, Chair, thank you.
Okay, thank you very much. We'll bring this back to the commission for comments. Mr. Clark, you was saying earlier, did you want to take a break to investigate your particular item that you want to look at?
It's not necessary, but are you closing the public hearing?
I will close the public hearing, yes.
Okay. Well, when the chair would like a motion, I would like to make one.
For discussion, yes, go ahead and make the motion and get a second and let's discuss.
Well, let me begin by saying that I wish I had a better authority for the question, the first of the 3 questions I asked. But notwithstanding that, I believe there's going to be an additional opportunity for the parties to argue their point. I believe this is or should be 4 parcels. So I move that we grant the appeal and the request by the applicant for 4 certificates of compliance.
I second that.
We have a motion made and we have a second by Commissioner Steele. Do we have any discussion on the motions? No discussion. We have a roll call vote, please.
Commissioner Clark?
Yes.
Commissioner Steele?
Yes.
Commissioner Stewart?
Yes.
Commissioner Peterson?
Yes.
Commissioner Sloan?
Abstain.
And Chair Terrell.
Yes.
Okay, so the motion passes.
Through the chair,
Yes, Mr. Clark.
could we ask staff to read the appeal process before we take our break?
Yes, I'm just going to get ready to do that. Thank you.
Thank you.
There is a 10-day appeal period following the County Planning Commission's decision. Anyone deciding to file an appeal must file the appeal at the Community Development Division by 5 p.m. Friday, August 3rd, 2012. The appeal must state the grounds for the appeal and be accompanied by a $125 filing fee. An appeal instruction handout can be found on the table between the front doors. Anyone deciding to file an appeal is strongly encouraged to personally file the appeal at the Community Development Division and is cautioned against mailing the appeal or otherwise using a third-party delivery system. An appeal and $125 fee must be received by Community Development Division by Friday, August 3rd, 2012, in order for the appeal to be valid. Thank you.
Thank you. With that, then, we'll take about a 10-minute break.